Hi, it's Nick Charles, and welcome back to the Rule of Law Brief. Before I get into today's topic, I think I need to explain something. Immigration judges are federal judges, but they are not Article 3 judges. They do not work for the judiciary. They're not part of the independent judicial branch described in Article 3 of the U.S. Constitution. They do not have life tenure, they do not have salary protections, and they are not institutionally insulated from politics. In fact, as we're going to describe here today, it's very far from the case. Immigration judges are Article 2 judges. They are administrative law judges inside the executive branch. And that means that ultimately they work for the President of the United States by, with, and through the Attorney General. That distinction is not technical, it is a structural fault line along which the entire system is starting to break down. Now, Article 3 judges are the judges that most people think of when they think of the courts. They are deliberately designed to be detached from politics. The basic reason for that is so that they can rule against the government when the law requires it. But immigration judges are different by design. As I said before, they are supervised by the Attorney General of the United States. Their decisions can be reviewed and even overruled by political appointees. And in fact, they operate inside the U.S. Department of Justice, which is inherently a law enforcement agency. They are not a part of the apolitical judiciary. And yet, and this is the critical point, they are still judges. Despite being part of the executive branch, immigration judges are still bound by the Fifth Amendment, and in particular, the Due Process Clause of the Fifth Amendment. The Supreme Court has said this repeatedly, and so have some of the lower federal courts of appeal. Removal proceedings are civil in nature, they are administrative, but they are still governed by due process of law as outlined in the Fifth Amendment. That means that every immigrant is entitled to a fair hearing, a meaningful opportunity to present evidence, and most importantly for this discussion, a neutral decision maker. Being an executive judge does not excuse that most basic constitutional obligation. And that's where the system is starting to tear itself apart due to a basic, fundamental, and structural contradiction. Congress built the immigration court system based on an assumption that presidents would respect due process norms even when they disliked the outcomes. In particular, they made the assumption that the President of the United States would not pressure immigration judges to rule in a particular way, that they would allow those judges to interpret the law neutrally and apply the facts to the existing law. That assumption substituted norms for structural safeguards. It was never enforced by statute, it was never guaranteed by the U.S. Constitution, and it relied entirely on presidential restraint. Under Donald Trump, that assumption has collapsed, and the entire system has started to produce distorted results. Again, the most fundamental principle of due process is this: the judge cannot have skin in the game. Judges must be neutral between parties. They cannot benefit from one outcome. They should never be in a position where they will be pressured, rewarded, or punished based on how they rule. If a judge has something to fear or something to gain from a particular result, that neutrality is gone. And when the neutrality is gone, due process has ceased to exist, regardless of intent. And this is the paradox that is currently causing structural collapse. We have an immigration court system that places immigration judges inside the executive branch. It subjects them to political supervision, and it floods them with enforcement-driven pressure. The bottom line is the Fifth Amendment Due Process Clause demands neutrality, while the statutes laying out our immigration court system place immigration judges in a position where they have to rule in accordance with the president's policies in order to be sure of keeping their jobs. Those two things cannot coexist indefinitely. Under Donald Trump's leadership, the tension has started to snap. The system is now at war with itself. What we're starting to see is immigration judges doing everything in their power to deport people without making it look like they are succumbing to the pressures that they are inevitably under. This is where doctrines like pretermission come in. Pretermission allows a judge to dismiss an asylum application without any sort of an evidentiary hearing on the theory that the claim fails as a matter of law. In a neutral environment, that standard is pretty narrow. A judge can only pretermit an asylum application if, assuming all the facts in the application are true, the person is still not entitled to asylum in the United States. But in a pressured environment like we have under Donald Trump, it becomes a release valve. Judges can dismiss cases without testimony, without any credibility findings, without developing an evidentiary record, and deport people whether under the law they would actually be entitled to asylum or not. This is certainly bad for asylum seekers who might be sent back to places where they are in imminent danger. But it's also horrific for the United States because it starts to erode the integrity of our judicial system. The more aggressively these judges shortcut the system to arrive at an answer that their bosses want, the stronger the argument becomes that the judge was not neutral. In a very real way, this is even eroding what Donald Trump claims to want from the immigration court systems. Because when it's very clear that an immigration judge entered an order in violation of the Due Process Clause, you are actually handing that asylum seeker grounds for an appeal. That just further binds up the system and makes everything run slower than it would have before. But even more importantly, the deeper harm here isn't tactical, it's institutional. Donald Trump, through his venality and his extremely poor leadership, is exposing a structural weakness in our immigration courts that cannot be unseen. Our immigration courts only function when the presidents voluntarily restrain themselves. And he clearly has not. That means that the system was never structurally sound because it relied on flawed individuals to do the right thing. I don't know if we'll ever fully recover from the revelation that we are living through right now. Once neutrality depends on executive goodwill we are clearly not going to get from Donald Trump, then the rule of law becomes conditional. And it's hard to avoid speculating that that might have been his goal all along. Donald Trump isn't just exploiting the immigration courts, he is exposing a paradox at their core. And now that that paradox is visible, I'm afraid the consequences might be permanent.